The ANC has been given 10 days to file its head of argument in a case lodged by the DA over the party's Cadre Deployment Policy. It comes after the governing party changed lawyers at the last minute. The DA seeking to force the ANC to hand over records of discussions and decisions by its Cadre Deployment Committee. It's in a bid to have the policy declared illegal. The court further asked the ANC to pay the DA's legal costs.
The first instance, of course, why you contest political power is to be able to make policy. And you do that through politically elected positions, whether that's the president, the premier, mayors, whatever the case may be. Is about the institution makes it very clear that that should be something that is independent and separate from party politics. In fact, Section 1973 of the Constitution says that no person may be advantaged or disadvantaged on the basis of party politics.
We're joined by DA Member of Parliament Leon Schreiber. Leon, good evening to you. Thanks for your time. So certainly one step closer to ensuring that this case goes ahead fully, but very far from actually getting to a point where the court makes a decision on this matter.
Yes, good evening, and good evening to the viewers. I think that's an accurate summary. I think that today's events, with the court order against the ANC and giving them a very clear deadline of 10 days to finally file these papers, which have been outstanding for 11 months now, at least I think brings to an end the kind of Stalingrad delaying tactics that we have seen in this case up to now. So that is certainly welcome. I think the important point to also make in this regard is that in terms of the order issued by the judge, that if the ANC now fails to submit those arguments within the next 10 days, then their opposition will be struck from this case, which obviously will significantly improve the DA's chances of getting an order on the merits. So we will certainly continue to push for the next court date to be as soon as possible after these 10 days have elapsed. And I think in this particular case, which is really about transparency and getting these records and information dating back to 2013 out into the public, I think can move ahead quite swiftly. Of course, we've got the second leg of our legal strategy, which is the case to abolish cadre deployment, declare it unconstitutional, which will then also be heard in January.
Ultimately, this case, of course, is a push in some ways for greater transparency. And political parties will always argue that they've been elected to positions, and because of that, then it is their duty and responsibility to ensure that the individuals they put, whether it's in government, whether it's in government agencies, will be able to execute the mandate of the organization. Is that the view of the DA as well, in as far as how you decide who must be placed where?
So it's just important briefly to distinguish maybe between the political positions, which are elected public office bearers. You know, this is like your MECs or your ministers or members of parliament or councillors. And of course, in that instance, it is entirely democratic for parties to fill those seats on the basis of votes that they got. So that's not what this is about. There are also a very small number of cases where political advisors or chiefs of staff may be appointed on the basis of political considerations, and that is also allowed for by the Public Service Act. However, outside of that, the Constitution in Section 1973 makes it very clear that the administration, the professional civil service, including government agencies or state-owned enterprises like ESCOM, for example, must not be politically appointed. They must be independent and professional institutions. And what we are submitting to the court is that cadre deployment, as practiced by the ANC, has erased this line and has therefore politicized institutions that should be independent and professional. So there is no legal provision that allows a political party to have a committee like this and to influence appointment decisions in this way. And in fact, to answer the substance of your question, the Constitution makes it absolutely clear that public servants who are working in the administration must loyally execute the policies of the government of the day. And where there is a case of public servants refusing to implement policies because they don't agree with it or for political reasons, action can be taken against them. So there is already a mechanism to prevent this kind of sabotage, if you want to call it that. And there is therefore no need for some additional layer, a sort of secretive political party committee to make these kind of decisions. These should be fair and open selection processes.
Of course, Leon, it is easier to sort of look at the ANC because they provide a bigger footprint in as far as their presence at national government. But we know that this is a culture that is not unique to national politics. In fact, if we look at the structure of our local government and even, part of the cancer that has eroded local government is that political parties very often are the ones that are doing the driving in terms of who should be placed in what positions. And I wonder then how much more broader you want to take this issue, because it's not only a national government problem.
Yes, I would agree with you on that one. The issue at municipal level is perhaps even more severe than at national level. But what is interesting is that we've recently seen the adoption of amendments that have recently been signed into law by the President, which actually prohibit officials working in a municipality. So municipal managers, directors, on the professional side of the municipal administration, prohibits them from actually holding positions within political parties. So I think that is a welcome development. We are working in a separate mechanism through Parliament with the Cadre Deployment Bill to replicate that at provincial and national level. But I think that amendment demonstrates the problem you're talking about, that it very much manifests at local level as well. And I would also agree with you that as our politics become more competitive and as we see the rise of coalition politics, it will certainly not be limited to the ANC. And I think that rather than somehow weakening the reasoning behind our case, that actually makes this legal strategy more important, because we frankly need to lay a marker in the sand now and get clear legal precedent on this to say that this is not allowed, so that when we go into this era of competitive politics and coalition politics, that we don't have other smaller parties also coming with this similar kind of practice. So I think it's really a very important moment for South Africa.
Leon, do you accept that that's part of the bargaining that takes place at a local government level, even with smaller parties?
I think that there are many cases where that does happen. So if I'm understanding you correctly, you're referring to things like municipal managers and directors in the municipal administration. Yes, but I think that is not allowed. That should be outlawed. There should be selection panels and fair and transparent selection processes that actually result in merit-based appointments also at municipal level. So I think the recent amendments to the Municipal Systems Act is a step in the right direction. And the important thing about our legal strategy is that should we ultimately succeed, it will set a precedent that says there is no such practice of a political party meeting behind closed doors and deciding who should be appointed into the administration that is legal or constitutional in South Africa. So it is a game changer in that regard if we can win here.
And in as far as the DA is concerned, are you saying that you don't need to discuss who your preferred members or individuals would be to certain positions?
So again, just to distinguish, we're not talking here about things like members of parliament or councillors where there are obviously selection processes within a political organization. This is about the professional administration side. And indeed, that is what I'm saying, that should not be allowed by any political party. And frankly, that is why this is a non-partisan issue. Because if we succeed in this case, the DA, other small parties, the ANC, the EFF, everyone will be bound by exactly the same constitutional framework, which then says that this is not allowed. And I think that is something that is in the interest of the public, because as we start going into this competitive era of politics, we're going to have lots of changes of government, and we need an independent and professional public service to keep the country standing and to survive the kind of political issues that may arise as we have changing governments.
DA Member of Parliament Leon Schreiber.